Good morning, wherever you are. Good afternoon, wherever you are, and good evening, wherever you are. Just a quick update on what actually happened in court yesterday. It's unfortunate, sir, and I ain't me any update, it was all because of time. But and then reacted to what actually happened in court. That was Enrano. You see, a lot of people have been struggling with at the Ankasa is see court. Once more, me welcome you will be out to the show, Face the Nation G, trending issues and rebuilding Ghana. Then yeah, ignore the trending issues for and then getting into court update as at the C court and rano. I think I can say see say it was let me make it so let me be very quick on that. Look, the purpose of yesterday as a Thursday, the purpose of the hearing was for the Supreme Court to set date for ruling because now Omar compelling both sides now, the petitioner and the respondent side, so almost for more closing or final arguments and fambra. At that point, they were telling them say almost these arguments and but then they will set date now for almost at the almost arguments. So almost arguments in the year that will be end. Meaning in that case about closure. Therefore Supreme Court has to fix another date they will come for hearing. And before that, once now there were two applications are not pending. That was an application and a pending as the ruling in our court in give on the 11th of February 2021. That was the basis of litigation on the subsequent. That particular ruling in our court in give was saying say Jane Adukwe Mensa on to me Jina Doketim, meaning on to me mounted witness boss. The issue actually that was before the court was a plaintiff or a party cannot compel someone to induce evidence. Okay, that was the issue. The court make sa ruling and you saw what Chikata did. Or make three moves. The first one was a party to me it was very strategic in its own way, and Oka said then obey use subpoena. Then Chikata declared intent to the court or file a subpoena. So the subpoena application was filing. Whilst Osan catch the court and say Osan so ebe appeal the original or the actual ruling about on the 11th. Here I'm going to use another authority to force the principal witness according to the petitioners to come into the box. Two, I'm also going to appeal the decision now really against us based on the exercise of judicial discretionary powers. So two things. Then Osan file what we call, it's called the motion of notice for stay of proceedings. In the moment Ubungu say I'm filing down notice of motion for stay of proceedings. So what they are trying to tell me is take your hands off everything. Yes, at that time they are even mandating the justices, okay? Because they also have to respect the civil procedure rules. Say, I'm going to take it on hands of it. Because if they're able to do that, a dear court in between. So, yes, idea as a way, it as a defendant in a file as a plaintiff in a file, or compel say, after so we'll take your hands of it, give attention to the initial ruling. So, this is what the court did. As at Enrano, even though not court not set a date to say, call Baba be here on them, no more finding date to bring the case to closure, and which was Thursday, 18th of February. Court not 2 or 3 cases in a chain. So this is what the court did. The court made them moved on with the argument for subpoena. Okay? And a court didn't dismiss subpoena. And you see, so there was back and forth with them. And some of them were saying, say, court, at that point, was supposed to rule on stay of proceedings, but where the argument was, say stay of proceedings, was protecting the subpoena. It is a court now making decision. Also, they use a word called say the case has been mute. Okay, in the moment I guess a case be a mute case, it means there's no live case anymore. Simply put, so now me person me call 2, okay, and now okay now me person me call 2, and already no by my drew 2 on my view. So why are you forcing me to get there? I don't know. Maybe this analogy wouldn't work, but let let me try to make it more simple. The purpose until almost filing the stay of proceeding, was to give the court attention to rule on their subpoena. And the court ruling on the subpoena. Therefore, therefore the stay of proceedings, are very irrelevant at this time. They are now would be protected. Yama ruling on, meaning court ruling against NDC for petitioners, Sorry, which is the petitioner, the NDC lawyers, That issue happen here, So almost the one stone equal two beds. That issue is aside. Now the second issue next that court here, original or the actual verdict now the bar on the 11th, that motion now almost dismissing. Now you get to appeal that motion. You know say, and that court in case okay, they never come Monday because as at that time, them say there was an issue with omni register and say one has been communicated, one hasn't been. But now let's get into the argument. It only dismiss subpoena. Okay. NDC foreigner argue on this basis. Say the court in the country almost say a party cannot be compelled to adduce evidence. Yeah, means party being to me shall be a machikata a movie for subpoena. Yes, I dismissing subpoena. Now arguments almost there and say they based on fundamental error of law to NDC foreigner causing miscarriage of justice to them. It is very simple. That was the issue before the court. Omokra at this point, they are blaming the Supreme Court. Say court and it's a court and ruling and omona suffer that bad fate of injustice. So if that is the case, the court should reconsider its decision and almost establish a very strong argument. The petitioners, the petitioner came out with this argument. Say, decision now must say more beki, it was without regard of the law. And quote here, local evidence section 26 of the evidence law. And catch it say, look, this is why a lot of people have been before studio. This is where I saw their problem was. Say, section 26 of Evidence Act, actually say, and then a court I relied on, say, to me enforce obi. They use a word like Estapol, the principle of Estapol. To me, enforce obi, money, bamba may give witness or adduce evidence. If the person doesn't want to do it, the court in the to me check the witness, what is adequate mensa Jane, but NDC also made what we call an inductive argument, okay? Because any deductive, it wasn't so clear for people. A lot of people were struggling to understand what the petitioners were trying to say. But from my understanding and my observation, what I believe is that what NDC was trying to tell the court is, in as much, also looking into down there, the section 26 of Home Evidence Rule, in as much as the principles of Estapol stated this, the same principle also says one can be, in as much as one cannot be forced to adduce evidence, the same way say any panels own to mean capitalize it on that authority or that principle not purposefully or deliberately. No, so I said I can say idea I was if that is the case, yeah, that person must be compelled. Then they further went to extend the argument or buttress our claim not making it say. You see chairperson adequate mensa bring a affidavit. Simply put, there was a disposition under oath. Or court one. We had a witness statement to them. Say, or that affidavit number actually say, about allowing itself to be cross-examined. Into which share the ruling of the court in regards to the inspection of documents and time and end this for example, sorry, petitioner no person serving with interrogatories. O share court na kasa own ruling na court no can send me. Say all these questions so mount box now move to me. So now the petitioner is challenging the first respondent. Say, and the court itself say, then obi are making an affidavit. Now if the more money go contrary to that. It won't say almost cite a case. Catch the court and say at this point, say there's a case court has also compelled a witness, Emmanuel give that statement. But all in all, you saw the defense, the first and the second respondent arguments or make court came out with ruling, okay? And almost denied that ruling. So I almost denied that motion. I know it did not go well with the NDC lawyers, but you see, one way or the other, no, that is the position of the law. I mean, one otherwise some alcohol, so you just have to accept it. Then almost I advance the issue about duty to testify, okay? Because the petitioners deemed or almost categorized it, adequate mensa Jane said, or a public officer, therefore should be held to account. I think that one, or I believe that one to the court did not hear them very well on that. Then Osha almost last argument no make it now. Okay, almost Chikata was arguing under what we call fair hearing or invoking section 26 and 24. So the court say it means the petitioner not freely say they've not been treated fairly, and that will also go against the justice system, or it will also be an affront to rule of law. So that was a simple argument, and the court put it forward. And the court also, as a petitioner, as argue on Estapol, as I've discussed earlier on. So when we in the court, they haven't convinced them so much, and therefore, this are ruling a buy. Look, the reason why some of us doesn't want to get into the public policy aspect of this now, okay? A play a role, but you know, MPC be pay attention to, and I see MPC be pay attention to, because when as per my observation, civil trial, I take it this trend. One, the tools of discovery are entitlement to a lot of people. You deny or more. And these are the essential tools that you need to litigate. So Monday, no, there is a Monday. This is what is going to happen. Court, likely be scheduled there, or more try, or more final arguments. As I believe it's been already submitted. No, the Monday is almost trial. Court be more dates, or the date be more. Normal be a final arguments. No, final arguments now. Then the next section, court more date to come for the hearing from the beginning of the case. They're not bringing case in hearing. But not forgetting the same Monday, no more another case in so air pending. This is check out the air appeal. They see the last two sections now. So let's see how that one also plays out. So as soon as a court hear them on some motion air pending, they are a bit more affected calendar and kakra. Look, I'm hoping that this case will come to an end. A big we'll be able to talk about how public policy so it play a role or how it impact. So all in all, no, I think they're now court decision how we make it, so to me compare will be Emmanuel Acheampong evidence. And then this one also counter actually say the move or the motive behind Jane Adukoya Mensah is so purposeful or deliberate, or she's in denial not to do that, purposely to suppress some evidence that the general public needs to know, and which will also be very vital where adjudication of this issue is concerned. In the almost it's like what can say in a reverse the amount. So that was the argument. But the thing is that the court did not hear them on. So I'm gonna dismiss Chikata review on submission, the end share what will happen on Monday. And let's see, maybe one or two sections, the whole proceedings, it will come to an end. Once more, Meda, OBBS, and so for time. That was just a quick update on what actually transpired in Ghana Supreme